When the law no longer protects you from the corrupt, but protects the corrupt from you, you know your nation is doomed. So guys, bringing you the court proceedings for yesterday, we all know that the court ruled in favor of the sitting president.
That much is clear. First, from paragraph 107 of the petition, where petitioners averred that the petitioners shall give evidence to show that the election results as purportedly declared by first respondent in respect of each
Supreme Court. So guys, Peter Obi has asked his legal team to move to the Supreme Court. So guys, after the final ruling yesterday that came as a shock to so many Nigerians, Mr. Peter Obi has instructed his legal team to move to the Supreme Court to file an appeal. Honestly, we are still looking forward to getting justice, because they can't just tell us that all the petitions, all the prayers before the tribunal do not make sense. That is what they actually told Nigerians. But we are going to get justice. Let me allow you listen to what Peter Obi's lead counsel got to say.
I'm saying that our clients are dissatisfied with the judgment just delivered. And we have the firm instruction of our clients to challenge the judgment on appeal. And the court has promised us that possibly by tomorrow we are going to get a copy of the judgment. Once we have it, we will swing into action. Let me say this. We have to be very, very careful in this country. If we are not careful, electoral jurisprudence will virtually disappear. I'm saying this with every amount of sincerity, because when the litigants, when those who contested the election continue to find it very difficult to establish their case due to obstacles all the way, starting by INEC, certainly they may resort to some other means of trying to seek justice, which may not be lawful. And nobody encourages that. Nobody encourages that. So, and also, I commend the Court of Appeal for introducing live streaming. You will recall that we applied to the court to have live streaming of all the proceedings. The court, in its wisdom, did not grant the application, but now in the end, they saw wisdom in it to guarantee transparency. Hence, they introduced live streaming of the judgment. Certainly, it would have been better if there was live streaming of the entire proceedings, so that the public will now watch it from beginning to the end and connect properly with the judgment. But this one just started from the judgment, so they didn't start from the very beginning. So I do hope and pray that next time it will be continuous from the beginning of the case, beginning of the hearing, until the end. That is the only way you can ensure transparency. Because when something is open, people will see it themselves and they will make up their minds one way or the other.
Thank you very much.
Finally, okay. I leave you with one word. History will vindicate the just.
So guys, you can see that Nigeria is a place where we hardly get justice. Justice is always far from the people. And one keeps asking, is the court still the last hope for the common man? If you don't have money and you don't have anybody in position of power, can you really get justice in Nigerian judicial? After the tribunal ruled in favor of Tinubu yesterday, honestly, Nigerians are not happy with the final judgment. It was far from the expectations of many Nigerians, and one keeps asking, can our constitution, our democracy, can they survive what happened yesterday? Take a look at the reaction coming from the PDP legal team.
Yes.
I want to get your reaction to the judgment and what next?
Well, go ahead, sir. 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 Well, the judgment has been delivered, but we have not received justice. Luckily, the Constitution has given us the right to go on appeal. This is a court of first instance, to go on appeal to the Supreme Court. And you see, this is a struggle that is not just for our clients, but for the constitution of this country, for the rule of law, for democracy. We were expecting an outcome that will improve, encourage the use of technology to enhance election management, to enhance transparency, to enhance accountability, so that Nigerians will believe in democracy. Nigerians will come out in their masses like they did to vote. We don't want Nigerians to be discouraged in the process. There are certain things, certain principles of law that we know that we need to explore, and we strongly believe that when we get to the Supreme Court, the Supreme Court will have the opportunity to review a number of things that have been said here today. So we have the instructions of our clients as soon as possible to go to the Supreme Court. So we have today, as you saw in court, we have asked for the records, we have asked for the judgment. We are going to apply for transmission of records because we have a very limited time to push this. So the struggle continues, and as it is said, it is not over until it is over. Thank you. Yes.
When they tell Nigerians, if you are not happy, go to court. If you are not happy, go to court. You think they mean business. No, they don't, because they know they've already positioned their men. They've got the power, they've got the money. And what do you expect? We can't wait to see if the Supreme Court will give Nigerians justice, especially young Nigerians who came out en masse to vote during the 2023 presidential election. Let's watch out to see how all this play out. Please subscribe and turn on the notification bell. Thank you. But protects the corrupt from you. You know your nation is doomed. So guys, bringing you the court proceedings for yesterday, we all know that the court ruled in favor of the sitting president.
That much is clear. First, from paragraph 107 of the petition, where petitioners averred that the petitioners shall give evidence to show that the election results as purportedly declared by first respondent in respect of each state of the federation, including the Federal Capital Territory, the details of which are contained in the table below, and table was given, are wrong. Then they proceeded to list each of every state of the federation. They also gave in the table wrong election figures declared by INEC for each state and FCT, Then in paragraph 147 of the same petition, they listed 60 different types of sets of documents they intended relying on to prove the said averment in paragraph 107 of the wrongness of results declared by INEC for each state and the FCT, the presidential election. Among those documents listed by them are A, BVAS CTC reports, B, Forms EC8 series, then EC8A, EC8B, EC8C, EC8D, EC8DA, EC8E, that's certificate of return received by petitioners' agents at the election. C, summary of the total registered voters on units basis. D, summary of PVCs collected on unit basis. E, data and event logs from all BVA's machines used in the election. And F, PVC collation records. These documents were specifically listed at paragraphs 147.1, then 6, 36, 37, 56, and 57 of the petition. These are the same averments to documents respondents are asserting were not pleaded by the petitioners and so irrelevant and inadmissible in evidence. They are indeed wrong. This ambit of the objection of respondents is therefore overruled and rejected. Then objection made by only the third respondent. The next set of objections to documents tendered by the petitioners were raised by only the third respondent, and now proceed to consider them. Admissibility of video clips. Arguments were advanced there on, okay. Okay. Yes. So we said, I'm however of the opinion that the contention is also misconceived, especially when regard is had to paragraphs 1, A, B, E, F, G of the certificate of authentication of the said video clips made by PW19 Dr. Ter. The authentication required by Section 84 of the Evidence Act in the circumstances the video clips in issue were made is statements assuring the court that they are in exact state, same state they were in the internet from where Dr. Ter, PW19, downloaded them to his laptop computer and subsequently to his flash drives before bringing them to this court. That much is evident in the contents of Dr. Ter's certificate in XBPAF 4B above. For the same reason, the argument of Dr. Ter is not the argument that Dr. Ter is not in position to answer questions on the said clips, and so his evidence on them is hearsay, is also non sequitur. Then there is also the issue of dumping of documents on court as ground for admissibility. With this one. Okay, that's part of the issue which will be considered deeply. Okay, you see, that is it. This is, okay. Some of them are listed. The simple and straightforward answer to this argument is that this issue, that the issue of dumping of documents on court, which expression in any case suggests that the documents so dumped are already in evidence before the court, only goes to the weight to be attached to the documents by the court. On this reasoning, this ground of the objection is rejected and overruled. Then also there is allegation that some documents tendered were either made during pendency of this proceeding, I think we have seen that, and anticipation of it by interested parties. I think we've done a little consideration of this earlier. So we'll go to number 3. They said also that exhibits PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD2A, PBD3, and up to PBF4, tendered by the petitioners through PW27, Mike and now Roeva, to show second respondent's non-qualification for the presidential election on grounds of his alleged conviction stroke fine in the United States of America, forgery of certificates and dual citizenships are irrelevant to the proceeding and so inadmissible in evidence, petitioners having not pleaded necessary facts in their petition to support them. This also was looked at by us, and Okay. And I have already ruled while considering the preliminary objection of the respondents to the petition and replies of the petitioners that paragraph 146 of the petition, where the petitioners averred to non-qualification of second respondent for 2023 presidential election, was bereft of facts to sustain it. I also held that the fresh facts of a second respondent's conviction/fine by a district court in Illinois in United States alleged forgery of documents and dual citizenship, all of which petitioners only introduced for the first time in their replies, were incompetent. They ran foul of both paragraphs 4.1d and paragraph 16.1b are incompetent, liable to be struck out, and were indeed struck out. I'm also aware that we have just few seconds ago ruled here in this judgment that evidence of PW 27, though through whom they say the documents SB is now impeached by third respondent were brought in, is incompetent for non-compliance to paragraph 45B of the first schedule to the Electoral Act. Those rulings constitute issue estoppel, binding not only on the parties but on this court too, meaning further that this court cannot depart from them. See Francis Shano and Afri Bank, and also Lawal Daodu and Cardoso and Daniel and all that. Consequently, the objection of third respondent to the admissibility of this evidence earlier highlighted, the objection is hereby upheld, and the said documents are further ruled inadmissible and expunged from the records of this court. The summary of all the foregoing is that 1. The objection to the evidence adduced by PW 12 witness Eguma Friday, PW 13 Grace Timothy, PW 14 Grace Ajagbona. Okay. Well, we said all those ones we have mentioned and also recouched here, we say that the objection is upheld, and that evidence together with the documents report tendered hereby expunged from the records of this court. See, it's there. Secondly, the objection of respondents to exhibits PAH 1, PAH 2, PAH 3, PAH 4 made by Mr. Samuel Odunton, PW 21, and exhibits PAR 1A to F made by Mr. Hitler Wala, PW 26, is also further upheld, and the said documents already held incompetent and inadmissible by earlier rulings are again hereby pronounced inadmissible in evidence on this ground too. Then the third one now, exhibits the objection of third respondent to the admissibility of exhibits PBD, PBD 1A, PBD 1B, PBD 1C, PBD 1D, PBD 1A, PBD 2A, PBD 3, PBD 4, PBE 1, up to PBF 3, PBF 4, tendered by PW 27, Mr. Mike Enauroeba, is also upheld, and the said documents are further ruled inadmissible and expunged from the records of this court. Save for these ones mentioned above, all other objections of the respondents tendered by the petitioners are overruled. Well, at this level, I hand over, like my brother said, to my leader to continue with the judgment. Thank you.
Well, I now consider the substantive matter, the substantive petition. I however wish to state that despite our conclusions above on the objections raised by respondents to documents tendered by the petitioners, I am still minded to evaluate evidence adduced and consider merits of the petition. The only evidence I shall not revisit are exhibits PBD, PBD 1A, PBD 1C, 1B, 1C, 1D, 1 PBD 1A, PBD 2A, PBD 3, PBD 4, PBE 1, 2, 3, 4, 5, 6, PBF 1, 2, 3, 4, and 4. relating to second respondent alleged non-qualification that were tendered by PW 27. Mr. Mike Inahoro Eba, the said documents, in our view, being bereft of pleadings to sustain them as elaborately stated earlier in this judgment. Coming to the hearing, the petitioners called a total of 27 witnesses and closed their case on 24th June 2023. The respondents opened their respective defenses starting from 3rd day of July 2023. The said respondent called one witness as one of his staff, RW1, and closed his case. The second respondent also tendered documents and called one witness, RW2. The third respondent did not call any witness but tendered documentary evidence. At the close of the case of the parties, the court ordered written addresses. The addresses were filed on schedule. In the final address for the first respondent filed on 14 July 2023, the learned leading senior counsel of first respondent, Mr. A.B. Mahmoud S.N., raised 4 issues as follows. 1. Whether, having regard to Section 47, subsection 2 and 3 of the Electoral Act 2022, paragraphs 38 and 92 of the regulations and guidelines for the conduct of elections 2022, and totality of evidence adduced at the trial, the inability of the first respondent to transmit the polling unit results electronically in real time using the BVAS device to the RF portal constitutes non-compliance with the Electoral Act if such substantially affected the outcome of the presidential election held on 25th day of February 2023. 2. Whether there exists cogent and credible evidence of corrupt practice to warrant the nullification of the presidential election held on 25th day of February 2023. 3. Whether, going by the provisions of Section 131 and 137 of the Constitution of the Federal Republic of Nigeria as amended, the second respondent was at the time of the presidential election held on 26th day of February 2023 not qualified to contest the said election. To remedy it through their replies to respondents' replies were belated and of no avail. That ruling constitutes issue estoppel, binding not only on the parties but on this court, meaning that this court cannot depart from their earlier ruling. So this issue is therefore discontinuous. This issue is whether the second respondent was elected by a majority of lawful votes cast in the. That's issue 4. Yes. This issue is whether second respondent was elected by a majority of lawful votes cast in the election, and first respondent was right in declaring him as elected. This issue covers ground 3 of the petition. The facts in support of this ground were pleaded by the petitioners from paragraphs 105 to 145 of the petition. The petitioners specifically pleaded in paragraph 106 to 107 as follows. The petitioners shall lead evidence at the hearing to show that A, the result of the election as announced by the first respondent, and especially the votes allocated to the second respondent, do not represent the lawful valid votes cast at the election. And B, the lawful votes cast at the election were deliberately and massively deducted this 17. The respondent in respect of each state of the federation including the Federal Capital Territory, the details of which are contained in the table following are wrong. The table referred to by the petitioners is the table of results declared by the first respondent. There is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So where the complaint in an election petition is that candidate returned did not poll majority or highest votes in the election to be returned as contended herein by the petitioners. Not only must the figures disputed be pleaded, the figures or votes the petitioner perceives as the correct figures of the election ought to be and must also be pleaded. That is not only logical, support for it can be found in several, as it then was said. When a petitioner is alleging that the respondent was not elected by majority of lawful votes, he ought to plead and prove the votes cast at the various polling stations, the votes illegally accredited to the winner, and the votes which ought to have been deducted from the supposed winner in order to see if it will affect the result of the election. Where this is not done, it will be difficult for the court to address the issue. See Awolo and Shagari, close of court. See also Ojo versus Isohe and others, Taba Jesse as it then was. The averments of petitioners in paragraph 107 of petition only showed the votes declared by INEC, which the petitioners are disputing as manipulated. Nowhere in the petition did petitioners plead that what they considered the authentic votes of the election to guide the court in the inquiry suggested by them in this allegation. The second respondent did not poll majority of lawful votes in the election. Their petition therefore did not meet the legal threshold to ignite a proper inquiry by this court, and so lame even on the pleadings. Going further, if we must at all, the petition claim is that 19,702 polling units results contains various forms of infractions. They assert that results from a total of 4,307 polling units are without stamp on the respective forms EC8A from the states, and details are said to be in the statistician's report, which report we have repeatedly held incompetent and inadmissible. They also contended that results from 1,300 polling units do not have signatures of the presiding officers on the respective forms EC8A. It was also alleged that results from 6,408 polling units have and indicate zero accreditation. It was further alleged that 9,464 polling units across 30 states showed that the votes returned are in excess of accredited voters. Furthermore, that the presiding officers failed to properly fill and countersign alterations in election forms, including forms EC8A, EC8B, EC8C, and EC8D in over 40,000 polling units, which they claimed were in the statistician's report. It is clear from the averments in the petition as captured above that neither the particulars of the polling units in issue nor those involved in the irregularities were given by the petitioners. In any case, our law is well settled that before a party can legally rely on fraud or forgery or any form of malpractice as alleged in this petition, the facts must not only be pleaded but particulars thereof must be provided in the pleadings. The petitioners in the pleadings from paragraphs 128 to 142 avert to issues of violence and disruptive activities. These allegations are criminal in nature. The standard of proof where an allegation of crime is made in an election petition is proved beyond reasonable doubt and not on the balance of probabilities. See Emmanuel and Umana. A complaint of massive suppression, deduction, and allocation of votes connotes forgery or fraud, particulars of which must be pleaded and prove beyond reasonable doubt. See Kaki and PDP and others, Ngobodo versus Ono. First, respondent joined issues with the petitioners' allegations in paragraphs 92 to 142 of the petition. The second respondent and the third respondents, in a similar manner, joined issues with the petitioners in calling on them to prove their claims as required by law. What this entails is that the petitioners who made all these allegations have the burden to prove all the allegations as required by law. The petitioners have placed reliance on the evidence of their statistician and forensic expert, who are PW21 and PW26 respectively, had time to look at the evidence of these witnesses and had ruled that their evidence, apart from being improperly before the court, is also hearsay. The statistician's report rolled out figures or forms which he claimed were either not signed or stamped, but none of the forms referred to was attached to the report. The polling unit agents of the petitioners who were present in all the polling units around the country were not called to testify to any problem or difficulties in their polling units on the 25th day of February 2023 presidential election. That is fatal to the petitioner's case. Thus, in Belgore versus Ahmed, it was said by Taba JSC as followed in the lead judgment. With respect to the volume of documentary evidence, I wish to state at the risk of repetition that they were merely tendered across the bar by Land Council for the petitioners at the trial. He did not and was not in a position to answer questions or otherwise speak on any of them. Their makers were not called. In such circumstance, was the trial tribunal bound to ascribe probative value to them? I shall answer this question in the negative. The trial tribunal had no duty to accord probative value to the mass of documents, their status as certified documents notwithstanding. There is no doubt that the petitioner's decision to tender the mass of documentary evidence at the trial was prompted by the urgency dictated by Section 285(6) of the 1999 Constitution as amended. That, however, does not diminish the petitioner or appellant's burden and standard of proof of the petition. They had a duty to prove their petition according to law, close of court. This position of the law may have been fairly watered down under the current electoral regime by Section 137 of the Electoral Act 2022, stating that it shall not be necessary for a party who alleges non-compliance with the provisions of this Act for the conduct of elections to call oral evidence if originals or certified true copies manifestly disclose the non-compliance alleged. But even at that, it cannot be gainsaid that oral evidence is necessary to explain discrepancies in original or certified true copies of election documents, where the complaint verges on whether an alteration or amendment in an original or certified true copy of a polling unit result was made with intent to falsifying it, or whether it was simply made to correct an apparent human error in the course of making entries in the result. Such situation would surely need a witness to explain or speak to the documents in order to prove falsification or election documents when it is so alleged, as pointed out in Belgole and Ahmed. See also the case of Waziri Ibrahim and Shagari and Buhari vs. Obasanjo. All the above, in my view, also explain the rationale for the employment of the adverb manifestly by the draftsman in Section 137 of the Electoral Act 2022. What the word suggests is that the non-compliance complaint of must be apparent on the face of the electoral document. It must not be something that can be explained away by oral evidence one way or the other. I have in this judgment explained the issues of evidence of witnesses who were not polling unit agents. The collection agents of the parties who testified were given accounts of stories related to them by people who were not called as witnesses in this petition. The interpretation of Section 137 of the Electoral Act 2022 by the petitioners was generously and swiftly silenced, the otherwise potent adverbial word manifestly used by the legislature in that section of the law. Manifestly is defined by online dictionary to mean in a way that can be readily seen by the eye or understanding, with the understanding plainly or obviously, evidently close, of course. This means for the petitioners to throw up their arms and say we need not call oral evidence in proving non-compliance as they are conversing. The certified copies of documents presented must be manifestly and readily seen to convey the fact of non-compliance. We have started this Oetolo and ANEC for the JSC. From this authority, it is the law that where the documents tendered and relied upon by the petitioners do not manifestly disclose the non-compliance alleged, the petitioners will still need to call witnesses who witness the alleged acts of non-compliance to testify. In the instant case, the petitioners tendered loads of certified copies of the document. The petitioners filed 5 schedules of documents. The first schedule was filed on 30th May 2023. The second was 31st May 2023. The third was 2nd June 2023. The fourth was 7th June 2023. And the fifth was filed on 21st June 2023. From these schedules of documents, a lot of exhibits were generated and tendered. These exhibits were objected to by the respondents. I had earlier in this judgment dealt with the documents and objections. However, I want to have a look at this document to see if they manifestly show any lack of compliance. These exhibits include the following: exhibits PG, PG1 to PG3, which were the printouts of bimodal voter accreditation system, VIVAS, for Abia, Adamawa, Akwa Ibom, Anambra, Bauchi, Bayelsa, Benue, Borno, Cross River, Delta, Ebonyi, Edo, Ekiti, Enugu, FCT, Abuja, Gombe, Imo, Jigawa, Kaduna, Kano, Katsina,